Hello students, myself Dr. Manoj Kumar Sharma. I am teaching in Rajiv Gandhi National University of Law, Patiala. I am teaching constitutional law. Today we shall be dealing with the topic judicial appointments and accountability. The topic we will be trying to find out the position regarding the procedure and appointment of judges of the higher judiciary, that is High Court and Supreme Court in India, to compare it with the position in US and Australia, to examine and understand the need and importance of ensuring accountability among the higher judiciary, and finally to understand the impact of Judicial Appointments Commission in 2014 and the impact of 99th Constitutional Amendment Act 2014. My scheme of presentation will be, first of all, I need to introduce the topic, then we will be comparing the position in US and Australia along with appointment of judges to higher judiciary under the Indian Constitution. We all know that judiciary has played a very relevant part, very important part in interpreting the constitutional provisions. So we will be dealing with some of the important cases of the Supreme Court of India, the reports of the Law Commission, Judicial Appointment Commission Act 2014 and 99th Constitutional Amendment Act, and finally we will be dealing with judicial accountability and judicial independence, the relationship between these two. To begin with, judicial independence and judicial accountability is sine qua non for ensuring justice, which is our preamble objective. The Constitution of India, the preamble to that Constitution, aims at securing justice, social, economic and political. In a country where the preamble objective is to ensure justice, it is very important that the judicial independence be ensured, and it be ensured that the judiciary is accountable to the masses. The judges be able to deliver justice, to decide cases without any fear and fervor. The independence of judiciary cannot be gainsaid in such a democratic polity as our country is. For the process, we will be dealing in the beginning with the Australian position. Students, so far as Australia is concerned, appointment of judges to higher judiciary takes place through a very detailed process. Public notices are issued by the Advocate General's Department. The Advocate General, he ventures into wide-scale consultations. The consultation process is with the AG's department, with the courts, with the federal courts, with the courts of family courts, and then after considering all the nominations which are received, a public notice is also issued wherein people can send in their nomination, they can express their interest in being appointed as members of higher judiciary. Their nominations are considered by an advisory panel which is constituted to consider the names and to recommend to the PM and the cabinet which names who are to be appointed as judges of the higher judiciary. The panel, once it's making a recommendation to the AG's office, the AG's office then gets an approval from the Prime Minister and the cabinet, and then the recommendations are sent to the Governor General for appointment as judges of the higher judiciary. Therefore, if we see the Australian position, we find that in Australia, wide consultative process is adopted for appointing the judges of higher judiciary, and it also involves issuing public notices wherefrom the opinion, the nominations from the public is received, so as to ensure judicial independence, so that no person is given a veto power in appointment of judges, such that the judicial independence can be ensured. Moving on to the position in the United States of America. In US, we find that there is judiciary at the provincial level and judiciary at the federal level. So far as judiciary at the provincial level is concerned, we have justices of peace, municipal and local courts, we have state trial courts, we have courts of appeal, and then we have Supreme Courts in each states. And at the federal level, we have federal magistrates, federal courts, federal trial courts, then special purpose courts, courts of equity, circuit courts, and all, and with the US Supreme Court. So far as the appointment of federal judges is concerned, you will note that Article 2, Section 2 of the US Constitution that gives to the President the power to nominate by and with the advice and consent of the Senate to appoint judges of the Supreme Court. Therefore, the President is to nominate the members of the higher judiciary, but then he is not having the sole power. The appointment of judges of the Supreme Court, the federal Supreme Court, that is done with the advice and consent of the Senate, as you can see from Article 2, Section 2 of the Constitution of the United States of America. So far as the process is concerned, if you see Article 2, Section 4 and Article 3, Section 1, there you find that these judges can be removed only by way of impeachment proceedings, which is a very rare event. They can be removed for conviction on account of treason, bribery, and other high crimes and misdemeanors. So far as appointment is concerned, if you see Article 3, Section 1, that says judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and the inferior court, shall hold their office during good behavior and shall at stated times receive for their salaries, for their services, a compensation which shall not be diminished during their continuance in office. If you analyze the judicial position in US, you find that nomination is made by the President and then it is sent to Senate Judiciary Committee. Senate Judiciary Committee examines those persons whose names are sent to it. It votes then, after considering the names, whether these names are to be sent to the Senate for floor test or not. Once the Senate Judiciary Committee decides that the names are suitable, they are considered suitable for appointment to the federal courts, then the names are sent to the Senate and the appointment is done by the Senate. Which, if you see the procedure, we find that number one, the appointment of judges is not in the sole hand of the executive. The executive, though, can appoint the judges of the federal judiciary, but then it is required to consult. It is required to consult and get it approved from the Senate. And of course, the names are scrutinized by the Senate Judiciary Committee. Similarly, so far as removal of judges is concerned, it has been ensured under Article 3, Section 1 that they cannot be removed by an ordinary process. They cannot be removed by the executive as such. They have to be removed by the legislature by way of impeachment, which is a very rare event. So far as their salaries are concerned, they cannot be diminished during their continuance in office. Their allowances cannot be diminished during their continuance in office. Therefore, the American Constitution ensures independence of judiciary in US. If we see the appointment of judges in provinces, we find they have adopted a unique method for the appointment of judges in the lower judiciary, in the judiciary in provinces. The appointment in almost majority of the provinces is by election. There is a varying tenure of 6 to 14 years in different provinces. They are appointed by election, and the accountability is also ensured as their reappointment is dependent upon their re-election from that constituency. In some states, the elections are held on partisan lines, on party basis, whereas in other states, the elections are on non-partisan lines. But then in provinces also, independence of judiciary is ensured by ensuring that they are appointed by election. So far as the Indian position is concerned, students, you will find that appointment of High Court judges is dealt with in Article 217, Clause 1, which says, every judge of a High Court shall be appointed by the President by warrant under his hand and seal, after consultation with the Chief Justice of India, the Governor of the state, and in case of appointment of a judge other than the Chief Justice of a High Court. If you go to Article 222, Clause 1, which talks about transfer of judges of a High Court, it says, the President may, after consultation with the Chief Justice of India, transfer a judge from one High Court to any other High Court. It must be noted that so far as appointment of High Court judges are concerned, the term used in Article 217 is consultation, and it is not, the concurrence is not used. Therefore, it brings us to the point whether the consultation means concurrence or whether it means only consultation, which implies that the judges, the Chief Justice of India is to be consulted and such other judges are to be consulted. In the Constituent Assembly, when the Constitution was being drafted and it was being enacted, Dr. B.R. Ambedkar, when the motion was moved that the word concurrence should be replaced, should be put in for the word consultation, it was opposed in the Constituent Assembly on the ground, as Dr. B.R. Ambedkar said, that we are not giving veto power either to the executive or to the judiciary. If we are not trusting the highest office of the President and the government officers, then we cannot give veto power to the Governor as well, to the Chief Justice as well. Therefore, they said it should be consultation. It should be full and effective consultation between different constitutional functionaries, and only then the appointment of judges of High Courts that should be made. if we look at the process of appointment of Supreme Court judges as laid down in the Indian Constitution, we find that Article 124, Clause 2 reads, every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal, after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose. Now, the provision very clearly reads that the appointment of the judges of the Supreme Court shall be made by the President, but it shall be after consultation with such of the judges of the Supreme Court. And if you read the proviso, it says, provided that in the case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall always be consulted. That means the Constitution very clearly provides that the Chief Justice the opinion of the Chief Justice of India shall always be taken into consideration, whereas the President can consult, if he wishes, he can consult such other judges of the Supreme Court and of the High Court as he may deem necessary for the purposes of appointment. Under the constitutional provision, if we enact it literally, it is not mandatory for the President of India to consult any other judges other than the Chief Justice of India in the case of appointment of judges other than the Chief Justice of India. Now, so far as the provisions are concerned, provision contained in the Constitution very clearly provides for that appointment of the High Court and Supreme Court judges shall be after consultation with the judiciary, with the Chief Justice of India. That means the Constitution has enacted aimed to have independence of judiciary, which is sine qua non for delivery of justice, that justice which is fair, that justice which aims at achieving equality, that justice which is aimed at having social, economic and political justice. Till emergency, the provisions contained in the Constitution hardly presented much difficulty, and they were implemented without any other problems. The problem arose during the emergency era, when certain judges were transferred, 16 judges were transferred from various high courts in the name of national integration by the then government. Mr. Justice Sankar Chand Himmatlal Seth was transferred from Gujarat High Court to the Andhra Pradesh High Court. Justice Sankar Chand Himmatlal Seth chose to challenge his transfer on the ground that he was not consulted and that there was no effective consultation with the Chief Justice of India. It was an attack, it was perceived as an attack on the independence of the higher judiciary, as it was perceived that those judges who do not toe the government line, they will be punished by transferring from one high court to another high court. Therefore, the matter was presented to the High Court. The High Court declared the order invalid. The full judge bench of the High Court declared the order as invalid because it came to the conclusion that there was no effective consultation between the judge with the Chief Justice of India. The matter came up before the Supreme Court of India. The Supreme Court of India came to the conclusion that there was no the consultation as contemplated in Article 222 and Article 217, that has to be full and effective consultation. It cannot be said to be a mere formality. In order to be full and effective consultation, there must be consultation in the sense of consultation. He must be consulted, and the opinion of Chief Justice of India must carry primacy so far as the transfer of judges is concerned, so far as the appointment of judges is concerned. And transfer cannot be resorted to in routine. It must be as an exceptional measure, not as a means to punish those judges who do not toe the government line. Therefore, the majority judgment of the Supreme Court of India in Sankar Chand Himmatlal Seth case clearly established the independence of judiciary, and it averted all attacks on the independence of judiciary by transferring those judges who were not toeing the government line. So far as the minority judges are concerned, they try to interpret Article 222 in the sense that transfer can only be with the consent of the judge to be transferred. They said the transfer must be read as consensual transfer, though the minority opinion was not accepted by the majority, and the majority only said that for the consultation in Article 222 has to be full and effective, and it gave primacy to the opinion of the Chief Justice of India, that he must always be consulted and his opinion must carry greater weight than the other constitutional functionaries. In first judge's case, that is in S.P. Gupta versus Union of India, AIR 1982, Supreme Court 149, the matter again came up for deliberation in the Supreme Court of India, where the Supreme Court of India was confronted with the same situation so as to interpret what is the actual import of the term consultation as used in various provisions relating to appointment of judges of the High Court of the higher judiciary. And the Supreme Court, after long deliberation, came to the conclusion that the word used is consultation and it's not concurrence, and therefore it must be interpreted in its according to its plain meaning. Therefore, the court came to the conclusion that consultation is used in the articles relating to the appointment of higher judiciary, which must be read as consultation and it cannot be read as concurrence. Therefore, the government was not bound to act in accordance with or in conformity with the opinion of the Chief Justice of India. The decision gave the government a free hand to appoint the judges to the higher judiciary. The executive was given power to supersede the advice tendered by the Chief Justice of India. The court opined that the government is to consider the opinion given by the Chief Justice of India, but it is not bound by the opinion given by the Chief Justice of India. The court opined that the opinion of all the constitutional functionaries who are involved in the process of appointment of judges, that stand on equal footing. Therefore, if we see this judgment of 1982, that gave more powers to the executive and brought it in line with the UK position, where the power is given to the executive to appoint the judges. Whereas if we contrast it with the US position, where the power is not given to the executive alone. As we discussed, in US, the power to appoint judges of the federal courts, that is given to the executive, but the executive can use that power, utilize that power only with the consent of the Senate, that is the legislature. Whereas under the SP Gupta versus Union of India, the power was given to the executive and executive was not bound to accept the advice tendered by the Chief Justice of India. Matter came up before the Supreme Court again. In Supreme Court Advocates on Record Association versus Union of India, popularly referred to as Second Judge's Case, AIR 1994, Supreme Court 268. Now here, the 7-judge bench decision in SP Gupta versus Union of India was overruled by a 9-judge bench of the Supreme Court of India. The most important contribution of this case is regarding the independence of judiciary and appointment of judges of the higher judiciary is that this case established beyond doubt that number one, that the opinion of the Chief Justice does not mean his individual opinion. It means collective opinion, and that the Chief Justice of India is supposed to consult, or rather he is bound to consult, 2 senior most judges of the Supreme Court when he is to give his advice to the Supreme Court, to the President regarding the appointment of the judges of the High Court and Supreme Court. That means the case established beyond doubt that the Chief Justice of India's opinion, that should carry primacy, should carry more weight, and his opinion is not singular opinion, it is the collective opinion which he has formed after consulting 2 senior most Supreme Court judges. Therefore, the stand which this case established was that once the opinion is given, collective opinion is given by the Chief Justice of India, that should carry more weight, though the executive can raise objection on the names recommended by the Chief Justice of India, and it can ask the Chief Justice of India's office to reconsider those names. But if the same names are again recommended, then the executive hardly had any discretion. Therefore, the case established that collegium system where the executive's role was minimized and the primacy was given to the opinion of CJI, rather the collective opinion of CJI, formed after consultation with the 2 senior most judges of the Supreme Court. The case also established clearly that so far as the appointment of Chief Justice of India is concerned, the senior most judge of the Supreme Court should be appointed as Chief Justice of India. Therefore, if we see the position prior to 1977, position after the SP Gupta's case 1982, which gave absolute, the 1982 judgment gave absolute discretion to the executive, though it was to consult the Chief Justice of India, but it was not bound. The executive had more powers, it could override the opinion given by the Chief Justice of India, whereas the Supreme Court Advocates on Record, the 2nd judge's case, clearly established that the union had no power to supersede the advice tendered by the Chief Justice, and it also established that advice is not the singular advice, it is the advice, it is the recommendation which opinion which he has formed after consultation with 2 senior most judges. When in 1999 a presidential reference was made to the Supreme Court of India, because the questions have arisen regarding the appointment of judges to the Supreme Court and to various courts, high courts, on the ground that there was no process laid down in the 1994 judgment regarding how consultation shall take place between the Chief Justice of India and other senior judges of the Supreme Court. Since there were allegations that other judges, senior judges of the Supreme Court were not effectively consulted so far as the appointment of the judges to the higher judiciary was concerned, a reference was made by the President of India to the Supreme Court in 1998 to reconsider the consultation process between the Chief Justice of India and other judges. A larger bench of 9 judges bench was constituted to deal with the situation. The bench opined that consultation does not mean consultation with the CJI alone. It is the collective opinion of the CJI formed with the collegium. The judgment introduced the collegium system for the appointment of the judges of Supreme Court and the High Court. Judgment established beyond doubt that consultation has to be with the plurality of judges. Sole opinion of CJI does not constitute consultation. For the appointment to the appointment of judges to Supreme Court, the court declared that the Chief Justice of India is bound to consult 4 senior most prisoner judges of the Supreme Court. And when he is to make a recommendation to the President of India, his recommendation should be accompanied by the opinion given by the advice given by the 4 senior most judges of the Supreme Court, that means the collegium, and it must be conveyed in writing to the President of India. Similarly, the court opined that when the judges of High Court are to be appointed, consultation with the 2 senior most prisoner judges of the Supreme Court must be made by the President with the Chief Justice of India. By the Chief Justice of India with 2 senior most prisoner judges of the Supreme Court. That means whether it is appointment to these judges, appointment of the judges of Supreme Court or appointment of the judges of the High Court, the case established collegium system in India where the opinion of CJI must be in accordance with the opinion of the collegium, and if any 2 or more judges give adverse opinion, no recommendation could be made to the President. That means that collegium system established that the judiciary, the Chief Justice of India's sole opinion does not carry the consultation as contemplated in the Constitution. It reinterpreted the provisions contained in the Constitution and it declared that the advice has to be in consultation with the collegium, and therefore no veto was given even to the Chief Justice of India, that if any 2 judges express adverse opinion, it cannot be, no recommendation can be made. And the court declared that the President shall appoint judges to the High Court and Supreme Court only in conformity with the recommendations so made by the Chief Justice of India after consulting the collegium. And though the judgment clearly established that though if the recommendation is made, the executive can raise those objections regarding the appointment of a particular person, but then if these nominations are again, these recommendations are again reiterated by the Chief Justice of India, the executive is bound by that recommendation. It cannot supersede that recommendation and shall appoint judges only in conformity with the opinion, recommendation made by the Chief Justice of India. It is worthwhile, having discussed the judicial trends on the appointment of the judges of the High Court and Supreme Court, it is worthwhile to see what the Law Commission has to say regarding the appointment of judges to the higher judiciary. If we see the 14th report of the Law Commission, this report expressed a great dissatisfaction with the current state of affairs in India. It said that the system is totally unsatisfactory, and it was contemplated in the 14th report that the appointments to the higher judiciary must be with the concurrence of the opinion of the Chief Justice of India. Therefore, the 14th report sought to establish what Dr. B.R. Ambedkar refused, because he said we cannot give veto power to the Chief Justice of India to appoint the High Court and Supreme Court judges, whereas, and therefore they suggested, they included the word consultation in the Constitution, whereas 14th report recommended that consultation should be read as concurrence. If we see 121st report of the Law Commission of India, it recommended that National Judicial Service Commission should be constituted so far as appointment of judges of higher judiciary is concerned. The Law Commission said that this commission should be composed of 11 members, that is, the Chief Justice of India, immediate predecessor of Chief Justice of India, 3 senior most judges of Supreme Court of India, then 3 senior most judges of the High Court, the Attorney General of India, Minister of Law and Justice, and an outstanding legal academician. The Commissioner recommended that recommendations of this commission should be binding on the government, and the appointment of the High Court and Supreme Court judges shall be made only in accordance with the recommendation made by the National Judicial Service Commission. 230th report recommended that the post of the Chief Justice of High Courts should be made non-transferable. If we see, we have to consult the Chief Justice of India on various matters pertaining to the High Court. The court was of the opinion, if the Chief Justice hails from a different state, he would not be in a position to assess the actual worth of the judges who are working there. He may not be knowing the antecedents of the judges who are working there, their proximity with the advocates. Therefore, it is worthwhile that whenever the Chief Justice of India has to be consulted, the post of the Chief Justice of High Court rather, that should be made non-transferable. It should not be, the Chief Justice should be from the same state in which the High Court is situated. Second Administrative Reforms Commission 2007 also recommended that the appointments should be through National Judicial Council. It recommended that National Judicial Council should be constituted, consisting to be headed by the Vice President, consisting of Prime Minister, Speaker of Lok Sabha, Chief Justice of India, Law Minister, Leader of Opposition in Lok Sabha, and Leader of Opposition in Rajya Sabha. Therefore, it also recommended that the power of appointment of judges of High Court and Supreme Court, which was currently in the hands of the Collegium, that should be taken away and should be given to the National Judicial Council, so as to ensure accountability of that Judicial Council, because there have been allegations against the conduct of various judges of the High Court and Supreme Court. Now, let us come to the latest developments. As you are aware, in 2014, National Judicial Appointments Commission Act has been passed by the Indian Parliament. The National Judicial Appointments Commission Act has provided for constitution of National Judicial Appointments Commission, which shall include the Chief Justice of India, 2 senior most judges of the Supreme Court, the Law Minister, 2 eminent persons to be nominated by the committee, consisting of CJI, Prime Minister, and the Leader of Opposition. And the Act provides that the appointment of Supreme Court judges shall be on the basis of recommendations of this National Judicial Appointment Commission, and recommendation of names should be on the basis of ability, merit, and such other criteria as may be prescribed. The Act provides that no such recommendation is to be made if any 2 members oppose the names, and the Act has continued with the practice of, with the President of appointing the senior most judge as the Chief Justice of India if he is considered fit to hold office by the National Judicial Appointments Commission. And the Act provides that the appointment of High Court judges other than the Chief Justice of India shall be made out of the nominations made by the Chief Justice of the concerned High Court. The Chief Justice of the concerned High Court should consult 2 senior most judges of that High Court before nominating any person for the appointment as the judge of that High Court or any High Court. The commission is also empowered that it can also make nomination of persons for appointment as High Court judges. These nominations, whether they are made by the commission or whether they are made by the Chief Justice of the concerned High Court, they shall be reviewed on the basis of ability, merit, and such other criteria as may be prescribed. So far as the appointment of the Chief Justices of the High Courts are concerned, the Act has laid down that inter se seniority of the High Court judges should be that should be the criteria, along with ability, merit, and such other particulars as may be prescribed. If we see the system which has been sought to be put in place by National Judicial Appointment Commission Act 2014 along with 99th Constitutional Amendment Act. So far as this system which is sought to be put in place is concerned, it seeks to abolish the collegium system, and it seeks to give those powers to the National Judicial Appointment Commission after this new act has been brought into force. But then, as we all all are aware of that 99th Constitutional Amendment Act is to be ratified by at least half of the state legislatures. Till it is after it is ratified by half of the state legislatures, thereafter only it can be notified by the union government. Therefore, there is a long way to go before the new act or the new scheme contemplated by 2014 acts that can be put in place. Now, coming to the other aspect of accountability, all of us are aware of that Article 124 clause 4, which talks about the removal of Supreme Court judges. It provides for a very cumbersome procedure for appointment, for removal of the judges of the High Courts and of the Supreme Court. Article 124 clause 4 provides that the judges of Supreme Court can be removed only by way of impeachment, and the impeachment, all of us are aware of, is a very cumbersome process, and perhaps this is the reason that not even a single judge has been removed through the process of impeachment till date. And for the removal of High Court judges also, similar provision is contained. Rather, the provision says that the judges of High Court may be removed in the manner provided in Article 124 clause 4. Now, coming to another aspect of independence of judiciary, which has been declared to be part of basic structure of the Constitution. We see some of the components of the independence of judiciary are that the appointments and promotions should be out of the control of the executive. Transfer should not be at the mercy of the executive. Tenure of judges should be fixed. It should not be as per the whims and caprices of the executive. The removal of judges must not be at the sole mercy of the executive or the legislative branch of the government, and that salaries and other allowances of the judges, they should not be subject to executive vagaries. If we look at all these ingredients and the position in Indian Constitution, we find that the Constitution of India has ensured independence of judiciary. But whether independence of judiciary is antithetical to judicial accountability, the answer is no. Judicial independence is not antithetical to judicial accountability, rather they are complementary to each other. So far as judicial accountability is concerned, or the accountability of the higher judiciary is concerned, no express provision is contained in the Constitution for ensuring the accountability of the higher judiciary, except that there is a provision contained in Article 124 clause 4 relating to the removal of judges. Since there is no external urgency and no provision contained in the Constitution for the removal of the judges, for ensuring judicial accountability, judiciary on its own adopted self-regulation, and it was restatement of the values of the judiciary that was adopted by the Chief Justice's Conference in 1999. Thereafter, we find that the Bangalore principles were adopted, which were based on UN basic principles of independence of judiciary, that is 6 basic principles: independence, propriety and competence, integrity, equality, impartiality and diligence. This apart, various other efforts have been made to ensure accountability. If we look back, Judges' Declaration of Assets and Liabilities Bill 2009, that was introduced in the legislature, but the bill failed to get support of the legislature and it could not be passed. We also have this Right to Information Act, and if we see an important judgment of the Delhi High Court Justice Ravindra Bhatt in Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agarwal 2009, we find that the single judge of the Delhi High Court, he came to the conclusion that the office of Chief Justice of India is public authority, and the information pertaining to assets, declaration of assets given by the judges to the Chief Justice of India, that is information within the meaning of Right to Information Act 2005. The court concluded that the information which is in the form of declaration of assets given by the judges of the court, High Court to of the Supreme Court to the Chief Justice of India, that is not given, that information is not held by the Chief Justice's office in a fiduciary capacity, and there is no bar to declare that information or to get that information under Right to Information Act. An appeal was made by the Secretary General of Supreme Court before the division bench of the Delhi High Court, but the decision of the single judge, Justice Ravindra Bhatt's judge, that has been declared, that has been upheld. Thereafter, we find another legislative effort was made to open accountability, that is Judicial Standards and Accountability Bill 2012. Judicial Standards and Accountability Bill, which was passed by the Lok Sabha on 29th March 2012, it provides for constitution of National Judicial Oversight Committee and for Scrutiny Panel. It provides for that removal of judges. After complaints can be made to this National Judicial Oversight Committee, they are to be scrutinized by the scrutiny panel. The committee is to be constituted of the eminent persons like the retired Chief Justice of India, the judges nominated by the Chief Justice of India, and other dignitaries, other eminent legal personalities. However, the bill has yet to see the light of the day. It has not been passed till date. Therefore, we find that the efforts, whether they are legislative efforts, whether it's 2009 bill or 2012 bill, these bills have failed to see the light of the day, and therefore even till today, so far as accountability in higher judiciary is concerned, that still is ensured only by the self-regulation. It is pertinent to mention here that the self-regulation, that monitoring and regulation by external agencies is resisted by the judiciary. And if we look back, there have been several instances of allegations of corruption, allegations of wrongdoing on various judges of the high courts. There have been allegations against the judges of the Supreme Court regarding sexual harassment, regarding corruption and all that. However, there is not any viable mechanism to check the corruption in the higher judiciary. Rather, the judges have resorted to self-regulation so far as to ensure accountability is concerned. After having discussed some of the ingredients of judicial independence and the process of appointment of judiciary, we can very well conclude that independence of judiciary is one of the cherished constitutional goals and has been held to be part of the basic structure of the Indian Constitution. The constitution makers have emphasized the independence of judiciary by providing for consultative mechanism for appointments to higher judiciary, and that Constitution of India did not give authority to any single constitutional functionary to appoint the High Court and the Supreme Court judges. Rather, the power was vested in the President, who was required to consult the Chief Justice of India mandatorily and such other judges as he may deem necessary. And the consultation with the Chief Justice of India has been held by the judiciary to be full and effective consultation, as we have seen in Sankar Chand Himatlal, Union of India versus Sankar Chand Himatlal case and the first judge's case. It must be remembered that judicial independence is not antithetical to judicial accountability. If we look back till 1993, the power was with the executive. The executive had overall control over the appointment of High Court judges and Supreme Court judges, as we see the position in UK is there. But then there was the process of consultation, though, and which was required to be full and effective consultation. But then if we see the up to that 1993-94 judgment of the Supreme Court, the opinion of the Chief Justice of India, though it had to be collective opinion, that did not carry much primacy, and the government could have superseded the opinion tendered by the Chief Justice of India, the recommendation made by the Chief Justice of India. The second judge's case and third judge's case have tilted the scales, the balance of power in favor of the judiciary so far as appointment of judges to higher judiciary is concerned. The second judge's case and third judge's case put in place a collegium system where the Supreme Court judges are appointed on the basis of recommendations of the Chief Justice of India, who is required to consult 4 senior most puisne judges of the Supreme Court. In case of appointment of High Court judges, they are required to consult 2 senior most judges of the Supreme Court. The role of executive in such matters has been reduced to a mere formality, and therefore we see that the executive, though can raise objections regarding the appointment of these names recommended by the Chief Justice of India, but it is not bound to appoint those judges. It is bound to appoint those judges. It cannot supersede the opinion, the recommendation made by the CJI in consultation with the collegium. So as we have discussed that there is no effective machinery, there is no effective mechanism for ensuring judicial accountability, and therefore there is a dire need to put in place a system for ensuring accountability, especially in the light of allegations against the High Court and Supreme Court judges regarding corruption and allegations of sexual harassment and other misdoings, it is high time that the law relating to National Judicial Appointability Commission that is put in place after consulting all the quarters of society. Thank you.